Diesel We the People News, one more time at it. We're talking about how to get remedy when no law enforcement is actually arresting certain criminals. For a hearing on the record that's been happening. However, they will come after you without hesitation. And they will lie and put innocent people in jail and say, hey, you must go to court to fight this because I got qualified as uh, immunity. All right? Never look straight forward, always look around you. Be able to protect yourself by any means necessary. Okay? And if you think this case is unusual, it's not. It really ain't, people. I know someone that went through some of this, not as depth as he did, but called the FBI agents, Texas um, Rangers, and the sheriff and all that as well. He didn't put it for on the record like this guy did, but he did call them and say, hey, a judge or a magistrate was committing crimes and all that, and nobody was doing nothing, which in fact, in law, in writing, the judge was committing the crimes.
This, according to public records request, is Christopher Duff. Funny how Duff refused to investigate criminal activity of judges and has now become a Superior Court judge. Let's hear from his campaign trail for judge.
Here are just a few of the reasons why I'm asking you to vote for Christopher Duff for Superior Court Judge Seat 9. As a resident of Orange County, I have been a career prosecutor and always protected victims' rights.
Always, except for this case involving corrupt judges, right, Chris? Isn't it a crime to make false and misleading statements to obtain a public office of honor, profit, and trust? Wouldn't an overt act of treason also disqualify you from public office? Lieb also contacted Nicole Sims, who works for the Orange County County Council. Apparently they are the attorneys for the County of Orange. You won't believe this. So you make a report of deprivation of rights, the sheriff contacts County Council, who provides direction, and then somehow your case is closed. But then when you ask for records of the factual foundation and legal basis for the closure, which involves communication with County Council, they tell you it's attorney-client privilege. Let's hear what Nicole Sims says about this after she refuses to provide me any conclusions of law she apparently told the sheriff.
I'm not going to comment on that, sir. I can't get into what I told them. I can't get into that, and that's attorney-client privilege.
Well, Nicole, we have a thing called the Constitution, and you can't use any rules or regulations to overrule or supersede rights secured by it. For you to do that requires an amendment, and there hasn't been one. The justices reiterated this in a case I'm sure you studied in school. It's Miranda v. Arizona, 384 U.S. 436 at page 491, and it says, where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. Under the Constitution, the people have a right to make official complaints and to receive the complete findings of fact and conclusions of law upon which every official act is taken against them. If you want to have a discussion with the sheriff, fine. But if you make a findings of fact and conclusions of law pertaining to an official investigation, you have no authority to refuse to provide that information, and neither does the sheriff. The people aren't required to have psychic mind-reading abilities to discover the nature of your official acts and the authorities you rely upon for doing them. If we don't know what you're doing and why, how could we possibly instruct our representatives that don't actually represent us to make any changes? Let's return to Lieb's report to see what he did with all this treason and dereliction of duty. Do you think he made a full, fair, impartial, and independent investigation of his own? Of course not. Here on the report, it notes that there's evidence I provided the deputies during the initial complaint at headquarters. The evidence is printouts of the court authorities I relied on to substantiate the claims I made. You might think Lieb would examine this evidence and read these cases. But the evidence report says neither he nor anyone else checked out the evidence. Now, I don't know if it was potentially scanned and he looked at it on some internal network, but I highly doubt it because there's no mention of him doing so in his reports and no conclusions of law based on that research. After avoiding actually conducting an investigation, he goes on to state, quote, given that there is no criminal activity able to be discovered from what has been reported, this case will be closed pending any additional information. I immediately reported the issues with Lieb's investigation to his supervisor, Lieutenant Knudsen, and the other officials in the chain of command, all the way to the sheriff. Knudsen replied in an email, quote, "Adam, thank you for contacting me with this matter. I will look into it and get back to you." He's never gotten back to me. According to public records requests, with the exception of Sheriff Barnes, none of the supervisory officials involved had subscribed an oath of office for any office beyond deputy sheriff. Let me show you some examples. Here's the employment history for Lieb Sergeant Aaron Weidenkeller. He was hired in January 95 and promoted to sergeant in September of 2016. The only office the department had was this one from 1994. When he became a supervisor, the public office he held and the duties required thereby changed. That's why he's required to take and subscribe a new oath of office. Same thing here with so-called Lieutenant Knudsen. He was hired in 1995, got promoted to sergeant in 2014 and lieutenant in 2019, yet only one oath of office in 1995. Now, I can tell you, at least in my former department, that promotions were a big deal and were commemorated by an official in-person ceremony with the chief. They were called swearing-in ceremonies, where everyone from the whole department was invited to witness the oath of office being administered to the official for the new position they were being promoted to and their new badge being pinned on them. Apparently, the Sheriff's Department has taken on a similar practice to the Irvine Police Department, where they have an unwritten policy of no longer subscribing oaths required by the Constitution. I also made a complaint to the Santa Ana Police Department, since it is the city where the Superior Court and Court of Appeal are located. My initial complaint was made to Sergeant Abel Alcantar, who was the acting watch commander. He refused to investigate or intervene. The recordings of our conversations are exhibits E4 and E5. When Alcantar refused to investigate, I contacted Chief of Police David Valentin directly. Valentin assigned Sergeant Hernandez to contact me. Hernandez also refused to investigate. Our conversation can be found in Exhibit E6. I then filed an internal affairs complaint against Hernandez and Alcantar. The complaint was assigned to Sergeant Michelle Macchiaroli. Here's what she had to say.
On the judges, yes, we were not going to investigate that as a criminal matter. That's correct.
I later received a letter from Internal Affairs Commander Roberto Rodriguez on behalf of Chief Valentin that my complaint had been investigated and that the allegations did not rise to the level of misconduct. Since when is treason not misconduct? Nearly all of these officers appear to be operating on an egregiously corrupt program not found anywhere in constitutional law, that whenever a judge makes an order, it's irrefutable and law. You heard Watkins say, it's not an unlawful taking if it's done with a court order. I can confirm this was not taught in my police academy or any police training I received. Other officers told me, for example, that if a judge was caught driving while intoxicated, they would arrest him. But when it came to investigating a complaint involving an unlawful order made by a judge from the bench, even if it was made without lawful authority and resulted in a crime, they would refuse to investigate.
Now, in Oklahoma, there's an attorney actually was doing investigation of that deal. Judge drinking and driving with a minor, and the officers even ignored that, people. So you tell me. All right, this is Oklahoma. He's talking about California, and this happens in Texas. So tell me this is not nationwide.
This is absurd, completely irrational, and has no basis in law. The law applies to everyone, and no one is above it. It doesn't exclude judges or any public officials in any way. Judges have to follow the law like everyone else, and their authority is limited to within lawful bounds.
P.S. Look at James Freeman. When a lady, judge, hit a motorcyclist and never spent any time in jail, but you and me would have. All right, and James Freeman is suing judges for criminal activity, but it's this lawsuit. They're not going to jail, are they?
I attended the Basic Police Academy in California in the year 2000. Every academy is taught from what are called learning domains that are assembled by the State's Commission on Peace Officer Standards and Training for uniformity. While there is a whole learning domain on constitutional rights, this single paragraph from Learning Domain 2 leaves no ambiguity. It says, quote, The U.S. Constitution sets forth the highest law of the land, which all public officials are bound by oath to enforce. Law enforcement officers are bound to protect the rights and freedoms of all individuals as guaranteed by the U.S. Constitution, Bill of Rights, and later amendments. I've also made it
especially when you vote for the sheriff to protect your rights, right? Policy enforcers, officers, police, or whatever you want to call them, right? They're contracted to the city of the corporation, right? But the city is the sheriff, in fact, in law, in writing, is supposed to protect you from the government intrusion.
at least 3 complaints to the Orange County District Attorney's Office, who has a special investigation and special prosecution unit that handles complaints involving public official corruption. 2 of the complaints were completely ignored. In the third and most recent complaint, I spoke directly with the supervising investigator of the Special Prosecutions Unit, Rick Bradley. Within a few weeks, I received an unsigned letter with no public official's name other than the letterhead stating, quote, "We were unable to identify and prove beyond a reasonable doubt that any violations have occurred." I followed up with another complaint for dereliction of duty for failure to investigate and intervene and demanded to know who authored the letter. There has been no response.
We're going to pause right there. It's getting a little long. What they are doing is because we, the people, or some of you guys call citizens, we've been too relaxed of being going by hearsay. Well, this is what the judge says, and it's law, and it's standing, and all this kind of stuff. But you don't never look up where he gets that authority to give such order. You never look up how the attorney gives that authority, or the police gets that authority, or the state gives that authority. We all are operating in hearsay, people. It's up to us to clear this hearsay out. This one man is actually trying to do something, while everybody's not doing nothing. So, one man out of millions, you think he's going to get justice? Maybe a little bit here, maybe a little bit there. But how can there be true justice for everyone if everyone don't even know the basic law? This is We the People News. Bye, y'all.